First of all, I want to thank everyone for being here. I want to thank the ACS for having us. Election administration, one of the things that we just heard Congressman Lewis saying over and over again was to open up the vote, let everyone vote, and to make sure that every vote is counted equally. And I think that that really ties into the panel that we'll be discussing today. We're going to be focusing on election administration issues in the November 2010 election in particular. So election administration, it is something that kind of flies under the radar for a lot of people. Maybe not people in this room, but I think in the public in general. But it includes a lot of things. Although it really kind of conjures up the image of what happens in the polling place on election day, it includes a lot more. It includes voter registration. It includes maintenance of voter registration rolls, voting machinery, drafting and producing ballots, drafting and producing voter information booklets, voting both at the polls, early, by mail and absentee, counting of ballots, canvassing, and certifying the results. That's all. There's actually more than that, but in the last few years, the time period for voting has also expanded a great deal, with more states allowing for early voting and no-fault absentee voting. Some states, actually today, voters are already voting in the November election. And these activities were usually carried out by local officials, county officials, not really with very much public notice until there's a problem. So in the 2000 election in Florida, it really put into sharp relief how election administration issues like ballot design or voting machine technology or voter registration could affect elections and spark massive litigation. It also showed the extent of local officials' involvement, be it county officials that are trying to interpret voter intent from pregnant or hanging chads, or the Secretary of State's role in certifying elections. Since 2000, the state and federal officials have become more involved in election administration. 2002's Help America Vote Act instituted new voting procedures in many states, such as provisional ballots, and placed more responsibility on state governments, such as statewide voter registration rolls. In addition, several states have instituted additional election administration requirements, such as voter ID or proof of citizenship in order to register to vote or to vote. And today, especially when elections roll around, we often hear accusations involving election administration issues. Allegations of voter fraud, voter purging, absentee ballot irregularities, voter registration errors, voting machine vulnerabilities, and disenfranchisement, and more. And with pre- and post-election litigation, the time period of elections can stretch out a great deal. So here to help us understand the issues in election administration in general, as well as in the upcoming election, is our panel of national experts. And in the interest of time, since we're running a bit late, I'm just going to give name and title. You can check in the bios to get their illustrious careers. We have Commissioner Gracia Hillman, who is with the U.S. Election, she's with the U.S. Election Assistance Commission. Robert Kellner, who is Partner in Chief of Election and Political Law Practice in Covington and Burling. Glenn Mangpangtai, who's the Director of Democracy Program at the Asian American Legal Defense and Education Fund. Tan Takaji, who's a Professor of Law at Ohio State University Moritz College of Law. And Brenda Wright, who's the Director of the Democracy Program at Demos. And we will get started with Commissioner Hillman.
Thank you very much. It has indeed been a wonderful day, and I am so privileged and honored to be a part of today's symposium. Before I begin, I want to just acknowledge the presence of several of my Election Assistance Commission colleagues. We have with us today Alice Miller, who is our Chief Operating Officer, and two members of our legal counsel staff. We have John Cheek and Bianca Gomez, who are here somewhere, I hope. Bianca and John, okay. And Stacy Fabre, who works in our executive office, and my assistant, Harriet Grigsby. Thank you all for being here today. I also want to take a moment just to pay acknowledgement to Dr. Ron Walters, who I know many of you know, who died just a couple of weeks ago, and he certainly was a wonderful voice in the discussion of voting rights. And he was certainly the first person, when I was brand new to Washington, D.C., who challenged me on whether nonpartisan voter registration would really make a difference, or should it only be done in partisan activities. And it certainly opened my eyes up to a whole different perspective on how people looked at voter registration and get out the vote. And I know he was always a thinker and a challenger and a true academic, and I certainly will miss him. I'm going to speak in bullet points so I can cover several topics in a few minutes, and will rely on your questions to engage discussion. The Election Assistance Commission is about not quite 7 years old yet, and it has developed to be an enormous resource for voters, for academics, obviously for the state and local jurisdictions who administer elections. And I invite all of you and encourage you to visit our website. We have a wealth of materials. I can quite candidly say never before have so many people been so informed about elections as they are today with the push towards transparency. There's a wealth of information. A number of handouts were made available to you today as well. I have been working in and around voting rights and voter registration and education and get out the vote activities for many years. And what I see is the Help America Vote Act is a bridge, or a link, if you will, to the Voting Rights Act. The Voting Rights Act provides rights that are really sacrosanct. And the Help America Vote Act was enacted to make certain that those rights will mean something on Election Day. The Help America Vote Act also provides protections for voters with disabilities, which is a huge, huge progress in assuring voting rights for our citizens. Key provisions of the Help America Vote Act: voting systems that can be counted on to produce an accurate count that can be audited, provisional voting to prevent administrative disenfranchisement, statewide voter registration databases that produce transparent lists, administrative complaint procedure so that everybody who feels that they were not fairly serviced on Election Day, they have a formal place to go to. And of course, adequate funding from the federal government to make certain that the states can administer improvements to federal elections. And that funding is made available through HAVA payments to the states. And if you want to know what a state has received in HAVA payments, you can visit the EAC website. In HAVA, however, Congress leaves the implementation decisions for these key provisions to the states. So that's where the rubber hits the road. I have made available today, and if you don't have one, we will make sure that you get it, what I put together and called a readiness checklist for elections. And it's a simple tool I put together for elected officials and others who were concerned to be able to answer questions that their constituencies had and to direct them in the right place. I would encourage you to select the issue that troubles you most about our process for elections and voting, and start to work on it now if you haven't already. Whether it's what causes long lines, malfunctions, shortage of poll workers, any other issue, waiting until the week or two before Election Day will be truly too late. And our election system depends on poll workers, on people who, while paid a stipend, volunteer their time to be present on Election Day, working on behalf of the election board or election commission to ensure proficient customer service to the voters. Poll workers are the frontline offense to ensure accuracy, and I encourage you and anybody you know to get involved as a poll worker. Election officials need skilled people to work the polls, and your participation would be truly appreciated. And let me end on a point by saying that there is a critical need for minorities of all races and persons with disabilities to serve as election administrators. There are over 7,000 election districts in this country. They may be state, county, city, township, whatever definition is given to the municipality. And as best I can discern, there are fewer than 100 people who hold the title of Chief Election Officer for their jurisdiction, whether at the state or the local level. And that would include all races and persons with disabilities. The diversification of this field would truly make a difference in terms of how people are educated and informed and how young people look at election administration, not only in terms of civic engagement, but also in terms of possibly a profession, a job to work in, and a way to make a contribution back to their community. Thank you.
Thank you. Well, I'm going to range a little bit far from the specific topic of election administration and from the focus on election day to what happens before election day and what happens after election day. The before part being the campaign finance system, and the after part being the recounts or contests or challenges that take place after the election, all of which is actually interrelated. In the lead up to the election, we've had a pretty profound change this year for this election in the campaign finance system, which is that it is now clear that individuals, corporations, really any non-foreign national person can put unlimited amounts of their own money into advocacy for a particular candidate or opposition to a particular candidate or political party. And they can do that through direct spending. They can do it also through political action committees that are formed to make these so-called independent expenditures. And that's become clear as a result of the U.S. Supreme Court's decision in the Citizens United versus FEC case, and also subsequent advisory opinions from the FEC. And in fact, just today, the lead story in the Washington Post is about these new campaign finance vehicles, which the Post chooses to call super PACs. I think what's going to happen, not so much that there'll be a lot more money in the system than there would have been before, because there was already a huge amount of outside money flooding into the system. But there's a lot more flexibility now to how the money is spent. A lot less time and energy has to be put into the sort of legal fine points of how to structure groups. It's just a lot easier to spend the money. It's easier to raise it, and it's easier to spend it. So we're going to see many more of these groups formed. I'm not so sure the aggregate amount of money will be different, but there'll be many more platforms, many more vehicles for spending the money, which I view as a good thing. I think we're going to have a very vibrant election year with many players involved in the process. The other thing, though, that people can do with their money is finance what comes after Election Day. If election administration does not run smoothly, then we end up with potential challenges to the election. And that could be a recount, a candidate that wants to recount the vote. It could be a challenge or a contest to the outcome of the election based on some allegation of fraud or impropriety that took place on Election Day. And unfortunately, to my mind, there are a number of forces that are combining to make it much more likely with each election cycle that we'll have these kinds of challenges and that they'll be fairly disruptive to the system. First of all, we have more and more regulation of Election Day. We have panels like this one. We have cadres of people who spend their lives thinking about election administration. And we have what I generally refer to as ethics sclerosis, which is as we try to add ethics regulations and rules, all of which on their own are a good thing, it is possible to have too much of a good thing. And at some point, the system sort of clogs up with all these good government rules. And that's a little bit of what we have happening. So where you have all these rules, you also have an incentive for lawyers to show up and to litigate over those rules. And when you have a campaign finance system that enables people to spend their money in many different ways, you have a way of financing all that litigation. So these forces are sort of coming together and creating a bit of an election day vortex, such that I would anticipate in this election, where we're going to have a lot of very competitive races, we're probably going to see more than the normal amount of election challenges and recount requests, at least. The other factor I should have mentioned is, it's now 10 years after Bush versus Gore. And in those 10 years, the number of people who practice what I practice, election law, has probably increased by 10 times. When I started practicing election law, there were just a few of us. Now there are legions of lawyers who practice or purport to practice election law all across the country. And there are armies, there are teams sort of lined up and ready to go. I've compared it sometimes to, the classic political scientist description of World War I, where you had all these armies lined up against each other and you just kind of had to have a war because what else are the armies going to do? And there's some of that going on in the election dynamic. So we have all these rules on election day, and the more rules you have, the more likely you are to have bases for legal challenges. We have all these lawyers lined up on both sides in both political parties, and we have a campaign finance system that is geared to finance all that litigation activity, which leads me to a prediction that we will see more of this kind of post-election day litigation than we have in the past. Sometimes it's appropriate, sometimes not. Probably on an aggregate level, it's not the healthiest thing for our society. Let me stop there.
Great, thanks so much. That was great. Hi, my name is Glenn Mukpantay from the Asian American Legal Defense and Education Fund. I would be remiss if I didn't recognize some of my colleagues. Tova Wang, who's done a lot of work with looking at foreign-born voters and immigrants, new citizens exercising the right to vote, and Terry Au at the Asian American Justice Center, who I don't know if she's still here, but has done really cutting-edge work in the field to make sure that new Americans who have come to this country, who have struggled in their homelands, have come to the land where the Statue of Liberty reigns free, to the land of opportunity and fairness and equality. And then they're called, and then they want to participate in the political process as well, that they want to make a better life for their families and for their homes, that they believe that the promise of democracy, because in their home countries, democracy was not something that often happened, or sometimes you get exterminated if you participate in the wrong democracy and the wrong political party. That for Asian Americans who are new to American political systems and who want to participate, come to the poll sites and face hostility, discrimination, and bias, and then they say, I don't want to vote anymore. It's too difficult. There's too many problems. I didn't think I did anything wrong, and yet I'm being called out for some of these issues. I was delighted that we had, the Congress member here to talk about the work and the work that he had done to move forward the reauthorization of the Voting Rights Act, particularly Section 203, the language assistance provisions that had made sure that language minority voters, Asian Americans, Latinos, Native Americans, and Alaskan Natives, can fully exercise their right to vote free of their inability to fully comprehend English. They may be learning English, but they are not there yet to fully comprehend all the aspects of a ballot, and so a translated ballot very much helps. And we're fortunate to have a DOJ that did work very strongly to try to litigate a number of Section 203 claims to make sure that jurisdictions fully follow those provisions and to some extent even exploit it a little further. But we find that there's a number of problems in the administration of 203, and compliance and the aggressive enforcement by the Department of Justice is very much still needed. We find, and as we saw, well, just to go over some of the prior problems that happened in elections, things like in 2000, which mistranslated ballots, and in Chinese listed Republicans as Democrats and Democrats as Republicans. Ballot instructions more recently that said instead of voting for 5 candidates, vote for 3 candidates, and a number of other problems. Most recently in New York, new voting machines that have a ballot where the text is about that small, and a bunch of Chinese senior citizens run up to me on election day and says, I cannot read the ballot. Here it is, it's right in front of you, but it's just too small. The ones who most need a translated ballot in the Asian American community tend to be senior citizens. Senior citizens who may have limited eyesight ability and also are exempt from the English requirement in the naturalization test because of their age. They most need it, and like the overall electorate, senior citizens, particularly Asian senior citizens, are the most robust voting population, but they have faced difficulties in trying to exercise their right to vote. Other problems like in certain jurisdictions or counties, interpreters all speak Mandarin Chinese, which is one dialect, but all the voters speak Cantonese. Or even one poll worker who says, well, here's the Chinese sign. And I said, oh, no, that's Korean. And then she says and looks at me, is there a difference? And I'm like, great. We have so much more work that needs to be done. Racial profiling in the Asian American community has taken a different experience than our colleagues, but is very well known. Asian American voters who've come to vote and they look foreign. They, don't speak English or are limited English proficient, therefore they can't be a U.S. citizen. That's impossible. Where is your identification? Or better, where is your naturalization certificate? No other voters are asked to bring their naturalization certificate, but certain Asian American voters are racially profiled. After 9/11, we saw that certain communities also had to provide additional forms of identification because, quote one poll worker, and we do need to diversify our poll workers, you never know who's a terrorist. But of course, it's only the Asian voters who are terrorists, right? Nobody else presents those complications in the United States. There are issues, and we are beginning to see this in much more activity with the issue of names. And names play out in two ways. One, in the context of a fully translated ballot, whether the names of candidates are translated into the Chinese, are transliterated into Chinese characters or Korean letters. And that is increasingly problematic as we see more Chinese language media outlets where an electorate, a Chinese American electorate that is much more familiar with the elections and with the candidates, but is still limited English proficient, and they translate names into the various issues and candidates. It's maybe easy to find the O in a presidential ballot, but how do you find the M or the N in a local election? And so the names, and then the other issue with names is, well, what is a name? If your name is Sin Yen Ling, what is your surname or your first name? And so we're beginning to see concerns where Asian American voters will come to the vote and poll workers cannot find their names in the voting list. So you can't vote today, we'll turn you away. Oh, but we have provisional ballots, don't we? Well, those ballots don't necessarily get counted all the time. So, I'm delighted there is HAVA, but we have a lot of enforcement work to do around HAVA or meet some of the challenges that HAVA actually does not state in its legislation that it needs to address, like correcting voter rolls and making sure that those issues happen. The last issue that I just want to talk about with provisional ballots is, again, DOJ enforcement, that as we will be monitoring the upcoming elections. I actually have some materials outside about all this election protection efforts and our work to make sure that all Americans can fully vote in the upcoming election free of discrimination, bias, and harassment, but we still need aggressive enforcement from the troops and from the community to report these problems to the voting rights advocates who can try to make a difference in people's lives. Thank you.
Brenda?
Oh, okay. Jumping ahead here. Okay. Well, first of all, thanks very much to the American Constitution Society for this great event. It's all been very inspiring, but in particular to listen to Congressman Lewis and Taylor Branch talk about the birth of the Voting Rights Act and what that meant and what went into it was really inspiring. And it got me to thinking about the topic of my talk, my comments, which is the issue of access to voter registration. And I could not help but reflect that it is really, it's both a puzzle and a shame that in September 2010, we have a panel on voting rights, and we are still, 45 years after Selma, talking about the basic issue of access to voter registration. The fact is that our current system of voter registration does continue to present a barrier to large groups of people. And, longstanding disparities, especially based on income in access to registration. In the 2008 election, which inspired a lot of people to come out for the first time, we still saw that while there were 84.6% of higher income Americans registered to vote, only 65.3% of low income Americans were registered in 2008. So, we need to talk about both some shorter term and some longer term solutions to that problem. In the shorter term, there is some good news out there, and Jim Dixon this morning alluded to this. Section 7 of the National Voter Registration Act of 1993 requires that state public assistance offices and disability offices provide voter registration services to low-income persons when they apply for benefits, when they recertify their benefits, or when they simply record a change of address with the agency. Now, that law was a very, very good idea. It was part of the what's known colloquially as the motor voter law. Most people are very familiar with the motor voter part of it. Fewer people realize that it also covered public assistance agencies and disability offices. And in fact, while the motor voter part of it has been fairly well integrated into most states' procedures, what organizations like DEMOS and Project Vote and Lawyers Committee have discovered through research starting several years ago is that compliance with the public assistance provisions of the NVRA had just dropped off the radar screen at many of these agencies in many, many states since the early days of implementation. And in fact, you know, by the most recent reporting period, the number of registration applications from public assistance agencies had fallen by 62% compared to the first years of implementation. This has been a real missed opportunity. And it's been a missed opportunity in many ways. The Department of Justice, of course, is charged with enforcement of the NVRA, but the Bush administration largely declined to take action under Section 7 of the law for most of the period they were in office until in 2007, 2008, Congress started holding some hearings and checking into the issue of state compliance. At that point, DOJ entered into some consent agreements with Arizona and Illinois, which was a positive step forward. But the promise of the law and the enforcement of the law has been, during much of this period, been left largely to private groups. Now, the good news is, and I did say there is some good news here, that when you do bring these enforcement actions and when states reform their procedures and put in good processes, the numbers of people seeking to register to vote at these agencies can just skyrocket. We've seen that in Ohio, where we entered into a settlement after several years of litigation in November of 2009. And in just the first 8 months of 2010, 138,000 people have applied to register to vote at state public assistance offices. By comparison, the 2 years, that's like 17,000 a month. And they were doing 1,700 a month in the years prior to the lawsuit. So it's like a 1,000% increase. It's really enormous. Jim Dixon mentioned Missouri this morning. Jim, you were actually a little bit low on the numbers because we have a few additional months to report. So we're up to about 250,000 people in Missouri who have registered or who've applied to register to vote at DSS offices there. And again, directly the result of litigation. These lawsuits, while they can be, you know, time-consuming, they're not as difficult as Section 2 lawsuits. You don't need complicated statistical proof and analysis of polarized voting patterns and all of that. It's often very basic. You send people into the offices and ask, can I register to vote here? And the answers that we get are, no, but you can go over to the library and get a form. Or, well, we had some forms here for a while, but we ran out. In Missouri, in one particularly egregious instance, they had actually been collecting registration forms from people who filled them out, and they'd been sitting on someone's desk for a year, never being submitted to the agency. So you know, these are pretty glaring, obvious, you know, easily litigated issues about noncompliance. And the problem is not isolated to just a couple of states. From the numbers that we see through the EAC reporting, from the investigations we've done, it's very widespread. There are a lot of litigation targets out there. So we're, one of the things that we're very concerned with is that we do want to get the Department of Justice back into the game. It's very important. We are a little bit disappointed that the current DOJ has yet to file its first action under Section 7. We're glad that they published some guidance for states for the first time under Sections 5, 6, 7, and 8 of the Act. That will be very helpful. But I hope that there's a number of voting DOJ attorneys in here who are just bursting to stand up and tell us that they're about to file a lawsuit. I know you can't tell us. You can't tell us until you actually file it. So I'm just hoping that some of you here are restraining yourselves. So, so that's one of the key things. There are literally millions and millions of people not getting the opportunity to register that Congress intended when it passed the NVRA in 1993. Let me say just a couple of words about some other issues around access to voter registration. Congressman Lewis alluded to same-day registration. Why do we have to have people still registering to vote 30 days out from the election, the same deadline that may have been in place 50 years ago, before we had computers? There are 9 states now that have adopted the process of same-day registration. And 3 of those states have had it for 30 years. It's a process that works. It's easy. It's very voter-friendly. Election clerks don't have to deal with disappointed people who've gotten all excited about the election at the last minute and then find out that the time to register has passed. And in North Carolina, which was the first southern state to adopt same-day registration, they implemented it in 2008 for the first time. 253,000 people used same-day registration to register and vote on the same day during the early voting period there in 2008. So it can have a tremendous impact on turnout and participation. So, but I think what all this comes back to is that we really shouldn't still be talking about overcoming barriers to registration in the 21st century. We need to go the next step. We need to really modernize the system and turn it into one where people are automatically registered when they reach eligibility, as the gentleman suggested this morning. If we can find people for the selective service, right? If they can find all the 18-year-old men in the country and make sure they're registered with selective service, we can do the same with the rest of the population and make sure they're registered to vote. We're going to need to have systems that allow people to have their addresses updated when they move, because this is a very mobile society. That's a big issue about having to re-register every time you move. And we're going to need to have a fail-safe, such as same-day registration, so that if someone inadvertently is left out of the system, they can fix that problem on election day. So we can say more about the modernization efforts that are underway as we go forward, but let me end there.
Thank you, Brenda. Dan?
Let me first thank the American Constitution Society for having all of us here. The opportunity to speak at a conference featuring Taylor Branch and Congressman Lewis was the proverbial offer that I could not refuse. These are 2 people who I have admired enormously. What I suppose I hadn't contemplated at the time was the difficulty for everyone on this panel of having to follow Congressman Lewis and the Congressman and Taylor Branch. What I'm going to talk about is a fundamental problem that we have not addressed in the past 10 years of election reform, the pervasive partisanship of American election administration, something that I think implicates all of the issues that have been discussed so far on this panel. And I also want to talk a bit about what I'm most worried about in terms of the manifestations of this problem over the next couple of years. So, as has been noted, it has been almost 10 years since the disputed election that gave rise to Bush versus Gore. We've seen a lot of changes on such things as voting technology, statewide registration lists. We've seen some improvements in disability access. We've seen voting become more convenient, with approximately 30% of people in the last election voting before Election Day, either through in-person early voting or mail-in absentee voting. Notwithstanding these significant changes, a fundamental problem that was at the heart of the 2000 election controversy hasn't been dealt with at all. 10 years ago, as you'll recall, many observers, and including, I'm sure, many of us in this room, suspected that things were not entirely on the up and up in Florida, right? We suspected that the people who were running that election, most notably then Secretary of State Katherine Harris, were biased. 6 years ago, in my state of Ohio, many people suspected the same of our Secretary of State at the time, Ken Blackwell, especially with regard to his decision not to accept voter registration applications that were not on 80-pound paperweight. Well, whether or not these officials or others like them are actually biased is, of course, impossible to say with 100% certainty. We can't get in other people's minds. What we can say with confidence is that conflicts of interest are pervasive in American election administration. In over 30 states, the state chief election official, usually the Secretary of State, is elected as a nominee of one of the major parties. In most of the other states, that person is appointed by a partisan elected official. This creates a clear conflict of interest, it seems to me, between the election official's duty to discharge their responsibilities faithfully to all their citizens and their own personal and political interests. This state of affairs, I would further note, is contrary to an emerging international consensus that election administrators should be insulated from partisan politics. As the influential Venice Commission has noted, only transparency, impartiality, and independence from politically motivated manipulation will ensure proper administration of the election process from the pre-election period to the end of the processing of results. American election administration, by and large, fails this test. Now, recognizing this problem is relatively simple. Figuring out what to do about it is much more complicated. It's not as though many states are about to hand over authority to independent institutions, although one state, Wisconsin, has a really good model of a relatively independent election administration. And moreover, even if we could insulate administrators from partisan politics, the institutions that are responsible for making election laws, which is by and large state legislatures, are certainly no model of impartiality. The most egregious examples in recent years are efforts in several states, most notably Indiana and Georgia, to impose strict photo identification laws despite the almost complete absence of evidence showing voter impersonation, the only problem allegedly solved by these laws to be a serious problem at all. Partisanship is thus a specter that haunts the making of election laws as well as their implementation. And I should emphasize that in the coming election, we've heard a fair amount of talk about how this election is going to influence the redistricting process. What we haven't heard so much about is how it's going to influence election administration. There are 23 states, by my count, in which secretaries of state who are chief election officials are up for re-election this year. I am extremely worried about what is going to happen in the period between 2010 and 2012. And what I'm perhaps most worried about is that there will be a move to impose more stringent proof of citizenship requirements that are going to impede participation by eligible citizens. We've seen this in the past in my own state of Ohio. I was part of a legal team that challenged a law requiring naturalized citizens to produce a certificate of naturalization if they were challenged at the polls. We've seen other even worse laws enacted in Arizona and Georgia, as was discussed earlier. Exaggerating voter fraud, especially when it comes to immigrants, has become a cottage industry in some quarters. There are some people running for Secretary of State's offices, most notably the Republican candidate in Kansas, who are running on an expressly anti-voter fraud, anti-immigrant platform. And I'm very concerned about what we're going to see in the next couple of years, especially if the polling is accurate about who's likely to control state legislatures and control Secretary of State's offices. Now, you know, I want to, just in closing, I'm talking now mostly defensively, and I think there is going to be a fair amount of defensive work that a lot of us are going to be doing in the next couple of years when it comes to election administration. But I don't think, and here I want to concur enthusiastically in Brenda's remarks, I don't think we can ignore a forward-looking, a progressive, affirmative agenda when it comes to voting rights either. If we look at the data about what measures actually are likely to increase turnout, same-day registration, election day registration is at the very top of the list. There's just no serious question anymore that this is a reform that will increase turnout. It's not going to get every eligible citizen voting, but it can result in a significant increase in the number of people voting. And I think defensively, we're going to have to organize, we're going to have to fight. We're going to have to fight in legislative bodies, and we're going to have to fight in the courts. Stop there.
Thank you. Okay. Okay. Yeah. And we'll do a chance to talk amongst ourselves. I just wanted to highlight, several of you mentioned the importance of poll workers, either the importance that they can play in making an election run well, or sometimes in causing problems for voters. And I think we can extend this also to election workers more generally, the county officials who are in charge of registration, in charge of actually administering the elections. And I was wondering if you all could speak a little bit more about poll workers.
Well, let me begin. The Election Assistance Commission has been compiling statistics to try to determine how many people are needed in the United States on presidential election day, and I'll use that since those are the most recent figures we have. And it has been determined that it is about 2 million. 2 million people in the United States of America are needed so that presidential elections can be administered. And that number could be higher. A lot of the restrictions are driven by budget. They may get anywhere from 2 to 4 hours, maybe 8 hours of training. They are all volunteers, and I often think how horrific it would be if the biggest event of your job in a year, you were dependent on hundreds or thousands of volunteers, people who had never worked in your office, who you have no idea whether they will show up on election day or not, and how they will perform and how they absorb training. But our system is fully dependent on poll workers. And for the most part, poll workers, I call them champions of democracy. They are people who dedicate a 12 to 16-hour day, take time out of their lives, in order to make sure that citizens can vote and are properly served when they show up to vote. So one of the things that the Election Assistance Commission has been doing is encouraging organizations, businesses, and corporations to think about poll worker service as a community service. If you're allowing your employees to take some time off to go into high schools or schools to tutor children on reading or math or whatever, then encourage your employees to participate as a poll worker, and that the employee can have the day without having to take either personal leave or vacation leave. Organizations can use it as fundraisers that their members would serve as poll workers, and the stipend would then be used as a contribution to the organization. The individual poll worker would make the contribution. There are many ways that we can do it, but the bottom line is that we need millions of people on election day in order for our system to be carried out. It's a system that's been in place for years and years and years. It's a community spirit. That piece of it is really good. In terms of efficiency and where elections are moving to, they are much more complex. And we ask an awful lot of the people who work as poll workers.
Yeah, it's the poll workers that are the barriers to democracy for certain communities. It is certain poll workers who believe that they have a little kingdom that they must protect from the big bad illegal immigrant who is very concerned in taking over U.S. elections. Not that they have other issues to deal with in their lives, but that are much more dire. And so therefore they are the defenders of, they're the new, unarmed minute people, or Minutemen, or whatever they were. So not to be too, polemical, but, it is a complex. But of course, we need to diversify our poll workers. We obviously need poll workers. They really do, a lot of work with limited training. I do want to recognize the work that was done in U.S. versus Boston, where in Boston, poll workers are never trained. It was remarkable to me how people could administer an election in the city of Boston but never receive any training on how the elections are actually administered. Until we filed a lawsuit. Well, DOJ filed a lawsuit, we intervened, we developed the fact pattern for them, for monitoring the elections for a number of years. And in that settlement, we said one of the things that poll workers must get is training. Training not only on how to not discriminate against a minority voter, but training on how to run the election. And I actually observed some of this. I actually think it's that kind of work, where litigation, in the language minority context, which most people think is a small part of the electorate, and generally it is, but can have a very profound impact and a positive impact that benefits the electoral process for all of us, I think works well. But you don't get there unless you have discrimination. You don't get there until you tease out that information. But I do think that it lifts the bar. It increases the opportunities for poll workers to understand how to run their elections. And there's some very positive things that can happen.
Quickly. I want to slightly differ here. Talking about whether we think poll workers are great or whether we're awful seems to me an unproductive conversation. Our system depends on volunteer poll workers, whether we love them or hate them. Now, other countries do things differently, and in my opinion, better. They have greater professionalization. They don't rely to the extent we do on an all volunteer force. Here's what we can do. We can channel more people towards voting before Election Day. And I'm particularly fond of in-person early voting. That's a way of taking the pressure off of polling places on Election Day so that it reduces the opportunity for things to go wrong at polling places where we either don't have enough poll workers or don't have very good poll workers.
Okay. And Robert, I wanted to touch on your point about the increasing regulation and increasing money and increasing election lawyers leading to more post-election day litigation, and how you think we might be able to fix that.
Well, I think, the fundamental problem is the increasing complexity of the election process itself. And when legislators or regulators or constituent groups think about election administration and election day, they ought to be thinking first and foremost about simplification of the process. And there are probably many ways that that could be done. And yes, we have to weigh the costs and benefits of each of those different approaches. But I don't think simplicity is a theme that we very much hear mentioned in the debates about election administration. I think if the code books are expanding as we work on election administration, then we're probably headed in the wrong direction. I think we ought to see very clear, simple model rules that can be replicated across the country with relatively increased standardization so that we don't have quite the wide range of diversity of rules that we have currently in different jurisdictions. With increased standardization and model codes, where the codes themselves are intentionally created to be simple and straightforward, I think that would by itself significantly reduce the risk of post-election challenges. Right now there's enough uncertainty in the system, enough diversity in the system, that there are probably too many opportunities to bring election challenges, recounts, post-election litigation, even where it is not really called for on the merits. Again, that's not to say that there should never be recounts, that there should never be election contests. There should be. Sometimes it is appropriate. But we can gear our system to disfavor challenges, or we can gear it to encourage them. And right now, I think the system is probably tending to encourage them.
Okay.
If I could just add a point to what he said, because it's certainly something that we have heard from local and state election officials, and that is, with the layering on top of new laws and new regulations, that sometimes they're not matched with existing, and there are unintended or intended consequences, depending on your point of view, I suppose. And some of it comes down to something as simple as whether or not our military and overseas voters can vote because their ballots have to be in by a certain number of days, but by the time the final ballot is produced because of a late primary, it's almost impossible to get that ballot to somebody who is in a distant land so that person can return it on time. And then there's the 1 or 2 states who have a law that says absentee ballots must be returned by U.S. postal mail. So you can't even return it in person, nor can you return it by FedEx or UPS. So those kinds of things have unintended consequences, and I think, you know, it would be healthy if certain things could be standardized, but I also understand that states push back real hard when they hear standardization, because they are the independent laboratories of creativity.
Yes, yeah.
Well, I think, I mean, I want to agree with the basic point that overhauls of many state election codes are in order, having looked at a number of them. At the same time, one of the things that I think we've learned over the past 10 years of election reform is that whenever you change a law, in the short run, at least, you're going to see more litigation because people have to figure out what it means. And this is, I think, agreeing with the commissioner's remark. I think the hyper-decentralization of our election system, the fact that we've got 50 state election codes and thousands of local election administrators, creates some real problems. At the same time, sometimes writing new federal laws that aren't completely thought through and that don't mesh very well with state law can exacerbate those problems.
Okay, well, we're going to open up to your questions. As a courtesy, we'd like to see if there's any members of the media with questions to let them ask first. Okay, seeing none, over here.
Hi, I'm Lenny Shambon. I have a sort of a post-game analysis question. How this Congress is wrapping down. It revolves around the question of whether we let the perfect get in the way of the good during this last Congress. At the beginning of the Congress, there were those of us who went to a meeting of the groups in New York and said, absent a crisis like Florida, you cannot go for the enormously creative, radical solution to any of these election administration issues. Think small. And instead, we had a year spent waiting for the universal registration draft bill that never showed up and did not deal with a more pragmatic approach, which the House was pursuing, for internet registration and internet correction of addresses. Similarly, we had a bill to deal with Citizens United called the Disclose Bill, which I think most people would recognize was a fairly complex piece of legislation difficult to pass when there were more pragmatic solutions being floated around. I'm wondering if Bob Kellner for Citizens United and Dan as an observer, plus the groups, can comment about whether this was a blown opportunity of reaching for too much.
Well, I'll comment on the Disclose Act, which was a campaign finance bill, and it certainly did fail because of its complexity, because it threatened too many different constituencies as a result of its complexity. I thought it was a dangerous bill. I thought it was poorly drafted and was very pleased that it failed because of that complexity. But certainly if my objective was to pass a campaign finance reform bill aimed at increasing disclosure, I would look for a narrowly focused bill making some very simple points. That does not seem to be the intent of the campaign finance reform community, and I think they frequently trap themselves in their desire to accomplish all things in the bill, and I don't really see that ending soon. I think the Disclose Act is probably dead for quite a while.
Can I jump in on I guess both of those? Apart from the Disclose Act, I think it's important to point out that the Fair Elections Now Act has also been a very important and ambitious initiative of the campaign finance reform community. I guess it's trying to get a floor vote this week is going to be the big issue. But a lot of energy around in the reform community was put on that bill that provides for public financing of congressional elections. And you know, you raise a difficult question of you know, how do you approach things strategically? Do you go for small steps, or do you go for larger reforms that really have the potential to move people and to capture the public's imagination and make real change? And I think you have to take a long-term view of things. I mean, it's hard to say that the Universal Registration Act bill failed because it never got introduced. Right. So you know, and I'm sure that those involved with trying to pull it together would cite a lot of reasons why that didn't happen in the past session. But you know, at the same time, if we're talking about smaller steps, it's important to get those right too. And so, for example, a number of states have started to look at forms of paperless registration, right? Internet registration and so forth. Mostly they're doing that by looking to use the driver's license process as the way in which the system gets automated. Well, I think it's very important for people concerned with voting rights to put down a marker in this discussion and say, we can't replicate the same problem that the National Voter Registration Act was designed to solve, which is there are disparities among different populations in their usage of driver's license bureaus, and we can't exclude people from the solution who are most in need of being reached by accessible forms of registration. So I mean, I think it's not an unhealthy thing that there's been a lot of discussion about how to do that in the best way. But I guess, you know, when I listen to Congressman Lewis, I come away feeling that there's a little bit of a chicken and egg problem in your question, that if you don't put out bold solutions that people can be inspired by, you're not going to get anywhere anyway. People are not going to feel inspired by the little nibbles around the edges of a problem. And that's an issue that is an important issue for the progressive community as a whole.
So I think, as usual, I'm largely in agreement with Brenda, but let me just make 2 points. First, I do think, in answer to your question, there was a missed opportunity, but I'm not sure it was because someone tried to do too much. I'm going to say now the same thing that I said, I believe it was the conference you were referring to in New York year and a half or 2 years ago, I think we should have pushed for a bill that would have required national election day registration for federal elections. A lot of people whined it can't be done. Well, we don't know if it can't be done until we've tried, and I would rather have tried and failed than not tried at all, which is unfortunately what seems to me happened. On campaign finance regulation, my personal view is that there's little more than tinkering around the edges that can be done constructively given the terrible decisions we've gotten from the Supreme Court, which has basically taken equality off the table as a rationale for campaign finance regulation. Citizens United is just the latest example. If you're interested in hearing more, Brenda and I, along with Jerry Hebert, will be on a panel at the University of Baltimore on Thursday that Professor Daniels has organized.
Over here.
Hi, John Tanner. Question for Gracia. You said that the EAC has gotten the data on the number of poll officials used in the United States. Has the Commission considered, or would the Commission consider, also gathering information about the race of the poll workers in the various polling places in the United States and whether or not they match the electorate and the precincts they served? It's been my fairly long experience that that gap and the mismatch is even today the greatest barrier that there is to minority participation in the United States due to the sorts of mistreatment that Glenn discussed.
I'm going to give the politically correct and the politically incorrect responses to the question. First of all, I don't think the EAC anytime soon would be able to, A, agree that it's necessary to collect that data, or that the states would be willing to collect the data. Okay. And so to the Justice Department folks and to the voting rights activists, as I said earlier, there's a bridge and a link between the Voting Rights Act and HAVA. And I really do encourage the voting rights groups to look at the provisions of HAVA and the kinds of things that may have an implication on voting rights issues. And to the extent that communities feel underserved by poll workers, then they need to have a real heart-to-heart with the election administrator to talk about the issues and raise righteous indignation. And also, the community needs to put its vote where its feelings and its mouth are. Because many of the people who administer elections are in fact elected officials themselves. And so they need to understand if the community feels that more improvements need to be made, then they need to just sit down and talk with them. And I know from my experience that election officials do. And I want to say that I have the highest respect for the both state and local election officials, many of whom work very hard. But a lot of times the community can't just passively say, this doesn't work for us, and say it to each other. They need to say it out loud and to the election officials and help a coming together around the issue.
Glenn, you had a...
There's a structural dynamic that's there in the selection of poll workers, which is, and it goes largely to Professor Kaji's comments here, which is the requirements that poll workers have to be a Democrat or Republican. For emerging minority groups, sometimes they don't want to identify a political party. We have identified that Chinese voters have a large numbers of voters who don't identify in a political party. But then if they're not there, or if they haven't paid their dues, or some have come through the political party structure, and so there's a requirement to do that, then they get shut out of the process. And so that's a structural deficiency that exists. Now, some jurisdictions have tried to diversify through their own local affirmative action programs to bring in more diverse poll workers. But that is very much not the standard. And I think it is part of this dynamic that Dan talks about in the partisanship of elections at the precinct level that does prevent certain minority groups from fully being able to engage in the political process. And sometimes our interests are not in line, minority interests are not in line with either party, and that's what complicates it, that the ability to do nonpartisan minority voting rights in this context and to make sure that everybody can vote is not necessarily what it's about. It's about the political parties being able to get their votes done and to disenfranchising everybody else. And that's a structural problem that I think needs to be addressed in more systemic ways.
Okay, and our last question is going to be ma'am right here.
Hi, Ann Morrison.
You wait for the microphone.
Oh, sorry. I'm ready. Hi, I'm Ann Morrison, and I am curious to know if, and I don't think it's been addressed, about the issue of access to voting by former felons, people who've paid their debt to society. And I was stunned hearing, I think it's mostly by state, I'm not sure, but just Florida alone was like hundreds of thousands. So what are the numbers and what's being done to address that?
So I don't have the numbers, but Florida's particularly bad because if I'm correct, if my memory is correct, they disenfranchise people permanently, although I think there is some process by which you can reapply. Other states disenfranchise felons only during the period they're on probation or parole, or only during the period they're actually incarcerated. So as you might imagine, this is a practice that has a huge disparate racial impact. What's being done? There have been efforts at legislative change. I can't say I've followed it terribly closely, but I believe some of those have been successful. I have followed more closely the litigation over this issue. There was a really good decision from the Ninth Circuit a few months ago, which held that Washington State's felony disenfranchisement law violated Section 2 of the Voting Rights Act because of its disparate racial impact. Unfortunately, that case was taken en banc, and I believe that their hearing en banc was held in the last week or two.
It's on Tuesday.
Yeah.
All right.
Also, just to add to that, the Democracy Restoration Act in Congress is legislation that many groups are working on very hard.
Okay, I'm sorry we're not going to be able to take more questions because we're already over time, but I want to thank you all for being here, and please join me in thanking the panelists for participating.